You know, when we think about lawsuits, our minds probably jump straight to those dramatic courtroom showdowns you see on TV, right? The surprise witness, the last minute confession. Well, what if I told you that winning in real life has way less to do with all that drama and a whole lot more to do with a strategic game? It's a game with a very specific playbook. So let's break down the rules to that game right now.
So, what does it really take to win in court? Here's the secret, and it might surprise you. It's often not about who's morally right or wrong. It's really about who can master the procedure. It's about a battle of strategy, a battle of rules, and you know what? Understanding those rules is your first step to victory.
Okay, so where does this whole game even begin? Well, first things first, before you can even make a single move, you need a ticket to get into the arena. I mean, you can't just sue someone because you're angry, right? The court requires you to have a valid reason, something we call the right to sue. Let's take a closer look at what that ticket actually is. And that ticket, it's got a very specific legal name, a cause of action. Think of it like this. It's the specific set of facts that you, as the plaintiff, have to lay out for the court. If your story doesn't check off all the right legal boxes for a recognized cause of action, well, the game is over before it even starts. No joke, it is the absolute foundation of the entire case. All right, so you've got your ticket, your cause of action, and now you, the plaintiff, are officially in the game. But how do you actually play to win? Well, it turns out there's a surprisingly straightforward three-step playbook. It's all about building your case piece by piece, moving from just a claim to solid proof. So, let's walk through it. Step 1, you allege the facts. This is basically your opening move, where you state your case. Step 2, and listen, this is where most of these battles are won or lost. You have to prove those facts. And not just with any old proof, but with admissible evidence. That's the stuff the court will actually listen to. Then finally, step 3, you move for judgment. You're basically asking the court to look at your evidence and declare you the winner. So you allege, you prove, and you ask. The steps sound simple, but let me tell you, mastering that middle part, the proof, that's the real challenge. But of course, every great offense has to face a defense, right? So now we're going to flip the board and look at things from the other side, the defendant's counter playbook. And their objective isn't just to block the plaintiff. Oh no, it's to try and dismantle the entire case before it even really gets off the ground. And here's where the defendant has a really unique advantage. Before they even have to file a formal answer to the lawsuit, they can launch what's called a flurry of motions. Now, you can think of this like a preemptive strike, a whole series of legal arguments all aimed at one thing, getting the case thrown out of court immediately. It's a seriously powerful first move to try and win the game early. But what if that initial flurry doesn't work? Well, then the defendant moves on to their main playbook. They file a formal answer. And this is where they can bring out something called affirmative defenses. It's a really interesting strategy. It's basically them saying, hey, you know what? Even if everything the plaintiff says is true, I still win because of this other fact they're not talking about. From that point on, their steps pretty much mirror the plaintiff's. They have to prove their own facts and then ask the court for the win. Now, when you see these two playbooks laid out side by side like this, it reveals something really crucial. You can see the defendant has that extra first step, that chance for an early knockout with the flurry of motions. But look closer at the core of both strategies. When you strip it all away, it all comes down to the same fundamental sequence. Allege your facts, prove your facts, and ask for a judgment. So, okay, we've got two different competing playbooks. But here's the thing. Both of them, plaintiff and defendant, they both hinge on one single, all-important goal. This is the common ground, the battlefield where the entire case is fought. And honestly, it's what ultimately determines who walks away the winner. In this quote, man, this really gets to the absolute heart of it. The entire game boils down to one critical action. You have to prove the facts you allege by getting admissible evidence into the court's official record. That's it. Whoever is better at doing that is the one who tips the scales of justice in their favor. So in the end, it's not just about the story you tell, it's all about the story you can prove. All right, so we've looked at the playbooks for both sides. We've identified the main event, that crucial battle of proof. So what does this all boil down to? Let's just distill this whole thing down into the fundamental rules of winning. So here's the biggest takeaway, the bottom line. Winning in civil court is almost never an emotional victory. It's a procedural one. It all starts with having that valid ticket to get in the door, your cause of action. From there, it's about methodically following the procedure, step by step.
You have to allege the facts to support your case, and then, most importantly, you have to prove those facts with admissible evidence. And if you do all that right, you can persuade the court to rule in your favor. It's a game of persuasion, for sure, but it's a game played entirely by the rules.
And all of this leaves us with a final, really big thought to chew on. We've seen that winning in court is based on a very structured game, a playbook of proof and procedure. So here's the question. If that's true, if winning is a game, what does that mean for our idea of justice?